Hi, my name is Laura Charpeau, and I am doing this presentation on Equal Employment Opportunity Commission versus Abercrombie and Fitch stores. What is equal employment opportunity? Equal employment laws were designed to protect United States employees from discrimination against race, color, religion, and gender. Equal employment laws also protect people with disabilities and women who become pregnant. The Civil Rights Act of 1964 ended discrimination against race in public places as well as workplaces. The EEOC versus Abercrombie and Fitch. Abercrombie and Fitch is a chain clothing store that has a very strict dress code. The store's dress code demands that their employees are to look in style while on the floor. The EEOC filed this case against Abercrombie as they were in violation of the Civil Rights Act of 1964, Title VII. The Civil Rights Act of 1964, Title VII, prohibits an employer to refuse to hire an applicant because of his or her religion practices when the practice could have been fulfilled fully without harm to the company. Facts of this case. The case began on February 25th, 2015, and it had ended on June 1st, 2015. Samantha Ulof was interviewed by Assistant Store Manager Heather Kook, who had noticed Ulof's headscarf during the interview, and she had been aware of it, but she had believed that she wore it in practice and belief of her religion. Abercrombie refused to hire Miss Ulof. Samantha is a Muslim who wore her headscarf, which is a part of her religion. Ulof was interviewed by store assistant manager Heather Kook. She had been noted that she had been interviewing someone that had been wearing a headscarf, and she was nervous that she would interfere with Abercrombie's strict dress code. So Heather Kook needed more clarification and had gone to the district manager, Randall Johnson, who had told Cook that the headdress would break all codes that they have. Ruling of the court. The court ruled with the EEOC in behalf of Samantha Ulof's case against Abercrombie and Fitch. The court ruled that Abercrombie broke the Civil Rights Act when they denied Samantha a job based on the girl who had been practicing her religion. The court ruled with Miss Ulof. Ulof sued Abercrombie for breaking the Civil Rights Act and denying her a job opportunity based on the practicing of her religion, that she would have been practicing her religion on company floors. Abercrombie failed, and it had been proven that they failed to make her aware of the dress code that they have set. They could have also made an exception to this dress code. The court deemed that Abercrombie did not make Ulof aware of the dress code, and it had been proven that there was an assumption based that she wore it for religious purposes, instead of having Heather Kook make the no head covering rule very aware, which had been proven that they have done in cases of interviewing people before. During the Abercrombie case, they has certainly added that Ulof felt she should have been asked about the policies, meaning Abercrombie went back and said, well, why didn't she ask us? Why wasn't she being proactive so this could have been avoided? At the end of the Supreme Court case, Ulof had been awarded $20,000. There had been a numerous number of circuits going about how whether or not it should have been a different case, because it was proven that it was directly intentional on discriminating against her, which has been proven that it's a different legal theory now. The First Circuit of rulings from the Supreme Court demanded that it was a direct discrimination. Abercrombie admitted, other than the head cap, she was very suiting for the job as a model to sell and promote clothing in their stores. Where is this case today? The case today had ended, however, Samantha had stated, I was a teenager who loved fashion and had been eager to work for Abercrombie and Fitch. In observance of my faith, it should have been prevented and I should have gotten the job. I am very glad that I stood up for my rights and am happy that the EEOC was there for me. Samantha was happy and hoped it had made others realize as well that this type of discrimination is wrong and the EEOC is truly there to help. Continued. The case had opened up Abercrombie's eyes in the sense of their policy, and since this case, they have now opened their policy to people who wear headdresses or caps based on the belief of their religion. It had been proven that they, after this, haven't denied either Jews who had wear a cap or Muslims who had come in wearing headdresses. Olaf, when she came for her interview, she had worn, it was fashionable with her outfit. It wasn't gawky, it wasn't a statement, it was more a practice of her religion to keep her safe mentally and stable. It had been shown that Olaf had been hired at Forever 21 in Old Navy, and then later on she had been hired as an assistant manager at Urban Outfitters. And then this is my Works Cited page. Thank you.